Picture this. You have been in the United States for 11 years. You came on a student visa, transitioned to H-1B, your employer sponsored your green card, your I-140 got approved, and your I-485 has been sitting with USCIS for the past 2 years. You have done everything right, every renewal filed on time, every status maintained, no violations, no gaps, no issues. You are technically eligible for a green card. You have been eligible for years. Last month, USCIS quietly released a new policy memo, and if you have a pending I-485 or you are planning to file one, that memo changes the ground beneath your feet in a way that most headlines have completely failed to explain clearly. Here is what actually happened, what it actually means for people on H-1B, and before you panic, the one thing that puts H-1B holders in a significantly better position than almost every other visa category under this new standard. My name is Nathan Reddy. I cover U.S. immigration news and green card strategy for skilled professionals. Subscribe and turn on the bell. This story is still developing and I will be covering every significant update as it happens. Let's get into it. What USCIS actually said in plain English. For decades, the adjustment of status process worked like this. If you were in the U.S. on a valid visa, your employer sponsored your green card, your I-140 got approved, and a visa number became available for your category and country, you filed your I-485, USCIS reviewed it, and if you met the eligibility requirements, you got approved. Eligible meant approved. That was the practical reality for the overwhelming majority of employment-based applicants. On May 21, 2026, USCIS issued a policy memo that reframes that entire process. The memo instructs USCIS officers that adjustment of status is not a routine administrative step. It is not something applicants are entitled to simply because they qualify on paper. It is, in the agency's own words, an act of discretion and administrative grace, an extraordinary benefit. Something USCIS grants, not something applicants automatically receive. What changed is not the law. The underlying statute still allows adjustment of status. What changed is the lens. Officers are now being told to ask a broader question when they review your I-485. Not just, does this person qualify, but does this person deserve to be granted permanent residence inside the United States rather than going through the normal process at a consulate abroad? That is a meaningfully different question, and it opens the door to denials that were not happening before, even for people who meet every technical requirement. Meet Priya. Priya has been in the U.S. for 8 years on H-1B. Her employer filed her green card through EB-2. Her I-140 was approved in 2021. Her I-485 has been pending since early 2024, filed the moment her priority date became current. She has a clean immigration history, a strong employment record, and 0 violations of any kind. Under the old practical standard, Priya's case was straightforward. Eligible. Processing. Approve. Under the new memo, a USCIS officer reviewing Priya's I-485 is now instructed to consider whether she has demonstrated that she deserves a favorable exercise of discretion, not just that she meets the eligibility requirements. The absence of negative factors, the memo says explicitly, is not enough on its own. Some applicants will need to show what the memo calls unusual or even outstanding equities, meaning positive factors that affirmatively demonstrate why permanent residence inside the United States is warranted for this specific person. Now, Priya's case is probably fine. H-1B holders are actually in a better position here than most, and I will get to exactly why in a moment. But the fact that her officer is now working from a different set of instructions than the officer who reviewed the case filed the week before the memo dropped, that matters. That introduces uncertainty where there was very little before. The two things this memo actually changes. The first thing it changes is the adjudication posture. Before this memo, the default lean in an employment-based I-485 case with a clean record was toward approval. The memo explicitly rejects that default. Officers are told not to presume approval. They are told to evaluate each case on its totality, weighing positive factors against negative ones, and asking whether the grant of adjustment is in the best interest of the United States. The second thing it changes is the consular processing expectation. The memo states directly that adjustment of status was never designed to replace the ordinary consular process. The ordinary process, in case that is not clear, is leaving the United States and applying for your immigrant visa at a U.S. embassy or consulate in your home country. For most Indian professionals in the EB backlog, that means traveling to India, attending a consular interview, and re-entering on an immigrant visa. The day the memo dropped, a USCIS spokesperson told reporters that foreign nationals in the U.S. who want a green card will generally be expected to return to their home countries to apply. Full stop. That statement caused immediate panic across the immigration community, and honestly, it should have. Because if that framing gets applied consistently, it would represent the most significant shift in employment-based green card processing in decades. Within days, the Department of Homeland Security walked it back, issued a clarifying statement saying nothing had fundamentally changed, that officers would continue making case-by-case determinations. But here is the reality. The original memo is still in effect. The walkback statement does not retract it, and nobody outside of USCIS knows yet exactly how aggressively officers on the ground are going to apply this new standard to cases already in the queue. That uncertainty is real, and it is not going away until adjudication patterns become clear over the next several months. Why H-1B holders are actually better positioned than most. Here is what most of the coverage of this memo has missed. Not every visa category is affected equally, and H-1B holders, specifically Indian professionals on H-1B with clean immigration histories, are in a meaningfully stronger position than almost any other group under this new standard. The reason comes down to something called dual intent. H-1B is a dual intent visa. That means the law explicitly allows H-1B holders to be in the U.S. temporarily while also pursuing permanent residence. Congress built that into the H-1B statute specifically, and the memo acknowledges this. It says directly that dual intent classifications remain compatible with pursuing adjustment of status. Compare that to an F-1 student. F-1 is a single intent visa, meaning the visa holder is supposed to intend to return home after their studies. If an F-1 student files an I-485 shortly after graduating, the memo creates real exposure. Officers can question whether the student had a preconceived intent to stay permanently when they entered on a student visa. That is a discretionary red flag under the new standard. H-1B does not have that problem. Your intent to pursue permanent residence is legally anticipated. It does not contradict the purpose of your admission. So, if you are an Indian professional on H-1B with a clean record, continuous lawful status, and no gaps in your employment authorization, your position under this memo is considerably better than the headlines suggest. That said, better positioned does not mean immune. And there are specific things you need to do right now to make sure your case is as strong as possible under the new discretionary framework. 3 things to do right now if you have a pending I-485. First, do not let your underlying H-1B status lapse. This is more important than ever under the new memo. One of the positive factors officers are now specifically instructed to weigh is whether the applicant has maintained continuous lawful status throughout their time in the U.S. A gap in your H-1B, even a short one, even one that was not your fault, is now a discretionary negative factor that your attorney will need to address explicitly in your filing. If your H-1B renewal is coming up, file early. Do not assume your pending I-485 protects you from a status lapse. It does not work that way. Second, build what immigration attorneys are now calling a discretionary evidence file. Under the new standard, the absence of negatives is not enough. You need documented positives. That means gathering evidence of your professional contributions, patents, publications, performance reviews, employer letters, describing your specific role and value. Evidence of community ties, charitable involvement, professional organizations, community participation, evidence of tax compliance going back years, evidence of your length of U.S. residence and the depth of your roots here. None of this needs to be extraordinary. but it needs to exist in your file. Because if an officer requests it and you do not have it ready, your case slows down significantly. Third, talk to your immigration attorney now, not when you get an RFE. The memo signals that requests for evidence on discretionary grounds are going to increase. The time to prepare your response is before you receive one. An attorney who has read this memo carefully can identify the specific factors in your case that could attract scrutiny and help you address them proactively. That conversation is far less expensive before an RFE than after. The bottom line: USCIS did not eliminate adjustment of status. The law has not changed. Indian professionals on H-1B are not suddenly at high risk of deportation. That is not what this memo does. What it does is introduce a genuine shift in how officers are approaching I-485 adjudications. The practical default that eligible means approved is no longer something you can count on. Some cases that would have sailed through before this memo will now face additional scrutiny. Some will face RFEs they would not have received previously. A small number, particularly those in non-dual intent categories with complicated immigration histories, face real denial risk. For H-1B holders with clean records and continuous status, the risk is lower than for almost any other group. But lower risk is not zero risk. And the way to protect yourself is not to wait and see. It is to understand what officers are now looking for, document it proactively, and make sure your file tells the story of someone who has earned this, not just someone who qualifies on paper. The people who get through this period without problems are the ones who treated this memo as a signal to act, not a reason to worry. You now know what to do. If this video gave you one clear thing you did not have before, share it with someone you know who is in the middle of an I-485 or planning to file one. They almost certainly have not heard this explained this clearly yet. Subscribe with the bell on. This story is still developing, and I will be here every time something significant moves. I will see you in the next one.